What do we do? Not defend people? Do we just... What do we do? Not defend people? Do we just do it by mob, or by consensus, or by newspaper, or by sound bites on television?
That's one way to respond when asked, how could you represent him? It's the question that criminal defense lawyers hear most, and it's the one on our docket for this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
How can you represent those people when you know they're guilty? Every criminal defense lawyer has been asked that question 1,000 times, whether by relatives at Thanksgiving dinner or by a stranger on a bus or at a party. I'm Ray Brown, and in some ways, it's a very logical question. Yet every defense lawyer knows in his heart that it is his duty to represent his accused client as vigorously as possible, no matter how convincing the evidence or unpopular the client. Still, since we tend to fight for people and causes we believe in, explaining that duty can be tough. But we're going to try in this edition of Due Process, beginning with Sandra King, who set out to get some answers.
Ray, this wasn't the first time I had asked the question. Like every reporter who's covered the courts and every person who's thought about crime, especially the really gruesome crimes, I'd looked at the lawyers at times and wondered, how could they?
Well, the question I hear most is, why do you defend somebody that's guilty?
And when criminal defense lawyers come together to sharpen their skills,
says that every syllable, nuance, tone is significant.
The idea, they say, is to do your best, even if your client is the worst.
Sometimes the most unpopular causes are those causes that you have to take up. Because if you don't do that, then the whole system means nothing.
But they'll all tell you that their commitment to their work is challenged every day, and usually by the same question.
Dozens of times, by all kinds of people. And in fact, I can remember reading a book when I was just starting in the practice with the title, How Can You Defend Those People?
It comes up frequently. Certainly, you know, that type of question was invited by the entire O.J. Simpson trial.
Whenever you're out with more than 3 or 4 people?
You always get the question.
Sure.
I'm a little insulted by the question, although I understand it.
I've definitely faced the question, both through family members, through other attorneys, in-laws, and more importantly, myself. I mean, I had to ask myself that question.
And Gerald Saluti, who left the Bergen County Prosecutor's Office late last year to make the switch to the defense side, says he's been able to answer them all.
I got to try a lot of cases as a young person, which is something you just don't get to do. I can't pay the bills working for the state, quite honestly.
But most attorneys who defend accused criminals will give you an answer more lofty.
It's America. This is America. Everybody has a right to a defense.
I don't think I was put on this earth, or I was put into this profession to make determinations about whether someone is guilty or innocent.
Still, for some defense lawyers, the question at times is not so easily answered. Just ask Tom Critchley, who made the switch from defense to prosecution.
I was involved in a case assisting another attorney representing someone charged with murder. He was found not guilty, and my sense of the case was that he had probably committed the murder, and I found that over time, that lingered in my mind.
Did you, at that moment, think, I can't do this for the rest of my life?
Absolutely not. It wasn't a revelation that struck me at that moment, but a lot of my thinking in terms of switching my career Some of it, I should say, was a reflection on what I had done, and I got the sense that I wasn't completely satisfied with having been on the defense side of that case.
But Tom Critchley's the exception. His Uncle Mike is more the rule.
Well, if he comes to me or she comes to me and says, I did it, we work out a plea bargain. We work the process to make certain that that person gets the best deal that they're entitled to under the system.
You wouldn't go to trial with that person?
I might go to trial, and I would not put that witness or that person on the stand because I could not knowingly participate in any testimony that would be perjurious, but I would put the state to its burden. The state has to prove beyond a reasonable doubt that someone's guilty, even a guilty person.
More often than not, you can find something redeeming in an individual or something like that, or a nuance in the facts or the allegations, which frankly, you can, with zeal and with good conscience, pursue and defend.
It's an adversarial process. Well, as a defense lawyer, to me it seems perfectly appropriate to vigorously defend a person's rights.
That's what I do. That's what the system's about. That's what the preservation of our system of government is about. Not only how can I should and I must.
I had to deal with the threshold question, can I represent individuals who may be guilty? Once I decided that I could be comfortable with that, then the next stage was, once I was in the field, how am I going to feel actually being faced with that situation?
And how have you?
It doesn't bother me. I sleep real well at night.
And so, he says, does our own Ray Brown.
The uglier the crime, the nastier the defendant, the more wretched a human being it is, the more vigorously you want to challenge the government, the more you want to put the government to the test. Because it's the concept. I've been in towns where for 8 weeks in a trial, nobody in the town spoke to me. I couldn't even buy a cheese sandwich at the local luncheonette. And what that does is it makes you more determined to say, they can't just get this person because he's ugly or because he looks like he did it. They have to prove it.
And lots of the lawyers we talked with spoke in those almost passionate terms, more like people with a mission than just a career. But there is, it seems to me, another question here, and Ray, you touched on it in your response. Even if you and your colleagues never second-guess yourselves, how do you deal with that outright condemnation from the public?
Sandy, defending the underdog is an ancient tradition, but there are special moments, as for example, when a couple of years ago I represented a person charged with killing someone of whom you thought very highly, and we had some spirited conversations in those days.
We did, and perhaps it wasn't condemnation, but I guess I did challenge you, and I think a lot of other people did, and I'll bet that happens to you again and again. How do you emotionally, even if intellectually you're absolutely at peace with the process, emotionally, how do you deal with people looking at you askance?
Sandy, before the trial, you never think about it, and afterwards, it's on to the next trial. And when we come back, we'll talk with a former president of the New Jersey Association of Criminal Defense Lawyers, and with another criminal defense practitioner who says that everyone is entitled to a lawyer, but that on some crimes, it won't be her. The conversation should be lively, so stay with us.
Well, number one, I wouldn't be a defense attorney. I even don't want to be on a jury because I would have the knack of sending the wrong person up the river.
I would represent anyone who would want to be represented if I was a good defense attorney.
I wouldn't defend anyone where the evidence was so obvious that they were guilty.
I would not want to represent them, but under the oath of law, you'd have to.
Defense lawyers?
Uh-huh.
Oh, well, it's their job, number one, but, financial matters, too. They do it for money.
They don't take principle into account.
I think guilty people have been set free, and I think on occasion innocent people have been convicted. So I wouldn't be a defense attorney. I'd probably be a prosecutor.
Well, that's easy enough for him to say, but let's explore this question with two folks who've actually had to make those kinds of decisions. Carl Poplar, a former president of the Association of Criminal Defense Lawyers of New Jersey and a fellow of the American College of Trial Lawyers, and Maria Noto, and a trustee of the Association of Criminal Defense Lawyers and a former public defender in Essex County. Maria, I understand there are some folks you just won't represent.
Well, more often than not, I will refuse cases where there are allegations involving sexual assault against a child.
So if a person is charged with that without regard to guilt or innocence or any other facts, you just won't deal with that kind of case?
Well, not necessarily. There are cases involving sexual assault allegations where I've taken the case, but those tend to be cases where there is overwhelming evidence of innocence. I just find that kind of charge so repulsive that I don't want to be involved in a situation where I've represented someone charged with a brutal sexual assault against a child. The person is acquitted and the person is free, as many people who do commit sexual assaults against children are. The person is free to do it again.
Did you gradually come to that position? Did you at one time handle such cases and get to a point where you wouldn't do it anymore, or has that always been your view?
At one time, I handled any case that was assigned to me, and I put my heart and soul into it and did it well. But, and that was during the time period that I was a public defender. And whether or not I found the charges extra repulsive, or whether or not I thought the person was guilty or not, I tried my best to win, and more often than not, in fact, probably more than 90% of the time, I won a case I tried. But I think it's an extremely stressful situation to be representing someone who's charged with a crime that for one reason or another is extra repulsive to you, and I don't want to be in that situation.
So for you, it's the nature of the charge and specifically child sex abuse cases. Carl, do you have similar feelings? Are there kinds of cases that you won't take?
No, I don't have any reservation to defend any specific category of alleged offense.
Why is that?
Because it's an alleged offense. It's not an offense until it's proven, and proven beyond a reasonable doubt.
What happens to the person who comes into your office and said, yes, I did it, and to sort of mix your case with that of Maria's, I committed sex abuse against the child, but I want you to represent me anyway?
Well, I would not hesitate to assume the representation of that person. My role as a criminal defense attorney is to represent people accused of a crime, and if there wasn't a zealous group of men and women defending people accused of a crime, not only will the guilty not be defended, but the innocent will not be defended. So
as you could see from the citizens we talked to in the street, it's not a popular view.
It's absolutely an unpopular view. That's what makes it more challenging. The criminal defense lawyer's role in our system of democracy is probably the most difficult of positions. The public is against you. Your fellow and sister colleagues in the practice of law are against you. The legislature is against you. You have to, in order to fight for the system, you have to fight for any client that comes into the office. But there's rules and there's standards that you absolutely comply with.
Maria, let me ask you a tough question, and I know it is because I know you're a very principled lawyer. I don't know anybody who's in favor of child sex abuse. Let's assume that it became widespread among criminal defense lawyers. They just wouldn't take those kinds of cases. Could there come a point at which you would change your principle just because you think everybody needs to be represented, or is that a fixed principle that you couldn't deal with from an emotional point of view?
Yes, I think there could come a point where I would be forced morally to change my position. I mean, as the situation stands now, there are many, many lawyers who would take on representation of someone charged with sexual assault against a child. In fact, there are even lawyers who prefer that kind of case and who like to be involved in the defense where there is that kind of charge. So I'm not in that situation now.
Let me see if I can. I know that you've presented some pretty strong defenses for people charged with murder. I know you don't like murder. Why is there a difference?
Well, you know, actually, Raymond, most of the accused murderers I've represented have been pretty nice people, and I'm sure you know from your experience in criminal defense work that people who are charged with murder tend to be the kind of an accused criminal who perhaps has only had that one charge in their whole lifetime.
Well, but all right, let me ask you a tough question, though. It may seem like I'm picking on you, but are there murderers who don't molest children, but who are nonetheless such rotten people that you wouldn't represent them?
Probably not. Probably not. I've never refused a murder case, and where there is not an allegation of sexual assault against a child involved, I probably would not refuse a murder case.
Carl, what would you say is the percentage of defense lawyers who have some category of offense that they won't deal with as lawyers?
Before I answer that, I disagree with Maria. I don't think that there is a huge number of lawyers out there that are willing to defend a difficult case. Separate and apart from the public defender, I think it's a very small and limited number of attorneys who are willing to do that. When you get past that very small core of attorneys, it's probably most of the attorneys are selective in what kind of a criminal law case they would accept.
And it's fair to say that child abuse cases where there's significant evidence is the kind of case that lawyers tend to shy away from?
Absolutely, but they're growing. The child abuse cases are growing in numbers. One, because of a heightened awareness of the problem. One, because of the number of social service agencies that are involved in ferreting out the problem. But with that comes a lot of false allegations. In the child sexual abuse area, there's some very serious and very terrible offenses, but there is a ton of cases that are probably untrue and false and being pursued for reasons unrelated to the event. And you need lawyers in
Does
those
that
cases.
suggest that there's a larger problem here because there are increasing numbers of lawyers who don't want to take these tough cases?
Well, there's always been a problem. At one point in time, many people were not even represented by attorneys. People were assigned attorneys who were uncompensated in the 50s and up to the mid-60s. And what we did since the mid-60s is we found that the Constitution requires people to have attorneys when they're accused of a crime. And the difference between persecution and prosecution very frequently is the involvement of a zealous defense attorney, and not to make judgments as to the gravity of the wrong.
Let me move you from description to analysis. Why is there such a widespread popular perception that lawyers shouldn't vigorously represent anybody? Why is there such a difference between the principle you've articulated and the popular view?
Well, there's a widespread hysteria about crime today that the statistics don't support. You know, crime has not been more graphic today than it has been in the past, but there is a greater amount of hysteria as to the amount of crime, and the defense attorney looks like the barrier between taking the person who is alleged to have committed a crime and putting that person in prison. You know that we now have over 1 million people in this country in prison, more people in prison in this country than anywhere else in the Western civilized world. It's only the defense attorney that can be the barrier between an abuse or a persecution or a tyranny.
Maria, we've watched on television O.J. Simpson's lawyer attacked pretty vigorously by Mr. Goldman, who has strong feelings because of his son. Have you seen and reacted to any of those attacks in terms of the perception that gives of defense lawyers and the more popular response?
Well, you know, Raymond, as Carl was speaking, I was listening very carefully to him.
That's first time?
And I always listen carefully to Carl. And one of the things he seemed to be saying is that we as criminal defense attorneys have a moral obligation to represent people who are accused. You know, after all, there's a presumption of innocence. But I have to be candid and say that many of these same people who are saying we have an obligation to represent anyone who comes to us and to do it well are only going to represent those people and do it well if they get paid, and get paid well for it. I am more likely to take a case at a reduced fee, no matter what the charge is, than I am to take a case involving an allegation of sexual assault.
So a person who's broke and charged with sexual assault, do you represent them?
No, no, and if they're rich and charged with sexual assault, I don't represent them either. But that's a general statement. There is specifically a case I have.
So in some way, are we being unfair to you in the sense that you think most of the folks who take what sounds like a principled position are really motivated by financial concerns?
I wouldn't make that statement, but I think certainly it is a factor in their decision. And as long as there are other attorneys around who will take any case, provided the person can pay, then I don't think that I'm under any kind of moral obligation to take whatever case comes into my office.
Do you only feel this way because of money, Carl?
Of course not. There's no question that money has a factor in the defense of criminal cases. You know, the more money a person has, the more resources that person can bring to bear in the defense of a case. No lawyer has the obligation to defend someone that they don't want to represent or don't choose to represent. But there is a need to have lawyers who are involved in the defense of criminal cases that were willing to accept those cases that would make you want to steel yourself to defend them with great vigor.
One of the lawyers in the package that we showed earlier told us off camera that he basically only represented people he liked. Is that a criteria that makes any kind of sense?
Well, we'd be out of business.
In the O.J. Simpson case, there came a point where he actually felt he needed security. I think it was the Fruit of Islam or somebody. And assuming that that was based on a sincere perception that he was that unpopular that he needed security, does that affect your view of how widely the public misunderstands or dislikes this principle?
The O.J. case does not affect my view on anything as it relates to the criminal defense practice. But there are times that you feel a little anxious and a little intimidated, but that just makes you be a little more competitive. Those lawyers who defend people are competitive people. You know, they have the desire to win, not at any cost, but they're competitive and they have to get tough, or at least pretend they're tough.
I want to make it clear that when I was talking about O.J., I was talking about Cochran being under assault and not the defendant. When you were a public defender, you didn't have a choice. You had to take any case that came in the door. Did that create difficult moments for you emotionally?
No. It didn't until the end of my tenure as a public defender. At first, when I was a public defender, I was so happy to be trying cases and loved it so much and welcomed the opportunity that my focus was more on what I was doing and doing it well and learning. But after 4 years of handling hundreds of cases as a public defender, I think my focus changed somewhat. One of the last cases I had involved a lengthy trial of where there were allegations of a very brutal sexual assault, and not only were the accusations so brutal, but the client that I had been assigned to represent was just a nasty person. He was nasty to everyone. He was nasty to the judge, the court attendants, and he was nasty to me.
Did that case help crystallize your feelings about not trying those kind of cases?
Absolutely.
Carl, is it your view that the nastier the person is, the more likely you are, all other things being equal, to be willing to represent him?
I never thought it in those terms, but if I was to reflect, I would probably say, you bet.
But have you known lawyers, either one of you, who at this point, based on this kind of experience, have gone over and either prosecuted cases or just become civil lawyers?
It's not infrequent that a young lawyer, after being involved in a complex or difficult or combative criminal case, will come to me despondently and say, I will never, ever get involved in the defense of a criminal case again.
And what do you say to them?
You try and encourage them, but the fact of the matter is that they won't. I mean, the defense of criminal cases is tough. It's tough dealing with your client. It's tough dealing with the prosecution. It's tough dealing with members of the public, including your family. It's tough, and you got to get past a certain hurdle in order to do it.
The example we've used of having people ask you this kind of question, how do you represent those folks at the dinner table or at Thanksgiving or family members, that's not hypothetical. Does that happen to each of you?
That happens all the time.
Do you have a good answer for them?
My answer is that everyone is entitled to a defense, and there is a presumption of innocence.
And after their eyes glaze over when you give them that response, is there a deeper way that you found of reaching or extending this message to folks who don't try cases and who are not involved in this arena?
Well, I try to be a little provocative when I answer that question because I think it's so inappropriate. I have that question even asked of me by attorneys. There's times when I'm involved in seminars that I'm delivering to attorneys, and they will ask me that question. But even in the new attorneys, when they have to go through a seminar program and they ask that question, I'm taken back by the fact that their law school training didn't give them the comprehension of the need to have criminal defense people who are sincere, zealous, and committed to their clients.
You say you have a provocative answer. What's your provocative answer?
Well, the provocative answer is probably best not said on television.
Oh, is that provocative? Okay. Were you surprised that one of the lawyers in our package had said that he actually switched and became a prosecutor as a result of inability to really wrestle with this and continue on in the face of his own and others' disapproval of this kind of representation?
I'm not surprised because that happens, and as we know, it's easier to be a prosecutor than it is to be a criminal defense attorney. I don't think it's as much fun, but I think it's a lot easier.
Something unprecedented, a quick answer from each of you. What's the future of due process in the criminal defense bar in face of the eroding belief in representing everybody?
Well, I think we're going to go in a downward cycle. I think that it's going to become less a due process system for the near future, and then ultimately when we categorize and catalog enough abuses, I suspect it'll come back again.
Maria?
I think that there will always be enough attorneys around to represent whoever needs one. And I don't foresee it as a problem.
And I hope that the two of you will always be included in that group. And that's it for this edition of Due Process. But we'll be back next week when we turn our focus from the defense of men accused of crimes to the protection of women from violence at home. Till then, for Due Process, I'm Ray Brown.
Comes in that's so repugnant to me, that the crime is so repugnant, or to any attorney, that he can't find himself to give 100% of everything he has, notwithstanding the fact that the press is against him, notwithstanding the fact that the crowd's against him, notwithstanding the fact that his wife might even be against him, then he can't take the case.
Has that happened to you?
Yes, but I've taken the case anyway, because I believe that that's our job. When you wake up in the morning, you've got to be ready to take on what's there. You've got to be able to do what you can for everybody, no matter what race they are, no matter what crime they've committed. And sometimes the most unpopular causes are those causes that you have to take up. Because if you don't do that, then the whole system means nothing.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.